about the cameras and stuff? Are they going?
I have no
As far
idea.
as we know, they are.
Okay, all right. Okay, well, this is the work session on HB 1258, which is the relative to the implementation of the Department of Energy. We have a new amendment, which everybody should have a copy of now. And we know there's one thing that we were going to put into this, Michael, maybe you can help with this, and that's Kat's other bill to combine it in here, so we'll have to work that in. That's simply just to take something that was in a separate piece of legislation and eliminate that and put it in here because it has to do with the Department of Energy anyways, and we'll discuss that.
Interestingly enough, it's 1285 going into 1258.
Okay. So we'll discuss that one afterwards. What I'd like to do now is, this will be a somewhat informal process. I'd like to ask the people from the Department of Energy, because they're the ones who wrote up the amendment basically, to just start from the beginning and go over what changes they made. So if you want to come up to the table here and we'll take it from there.
Good morning.
Certainly, just, excuse me, a question from Chairman Vose.
So my question is, does this amendment reflect the document that we shared with OLS as far as you're concerned?
Yes, sir, it does. But there is one mistake in what I sent over to OLS, which we'll talk about as we go through.
Okay, well, gentlemen, you have the floor.
So how would you like to proceed? Would you like to just go through the amendment itself?
Yeah, I think we should just start on the beginning of the amendment and go through and just, some of these are going to be fairly simple, just, you know, replace PUC with DOE, but others may have a little bit more background that we want to talk about.
So Section 1 of the bill, or of the amendment, is identical to what was in the bill as introduced. There were no changes made in that section. In Section 2, this is part of the change that modified the bright red line and which made the department an automatic party to proceedings before the Public Utilities Commission. Okay.
Excuse me, on Section 2 of this, I have a note here from, this is having to do with, I'm not sure if this is the right place, but it looks like we're talking about the rules here. I guess it would be Section 3. And there was talk of a 5-year rule review that we discussed in the last meeting, but I don't see that in the bill anywhere. And that was to try to clean up some of the problems we had identified from the past.
Right. And my apologies, I did not include that in what I provided to you for OLS, but there's no objection to putting a 5-year period in there.
Come up with the best place to put that in then?
Yes.
Okay, because we want to make sure, I think that clears up another problem so we don't have to pass any additional legislation. Who's got the question? Jackie, go ahead.
Section 2 on page 4, we're not there yet, right? That one,
Just go through them when we'll get to
go through them, when we
yeah.
get to that, I have a real problem with that.
Okay. So anything else on page 1?
I just have a question.
Sure.
On Section 2, I was just reading through it as you were referring to it, and it says that any confidential information in discovery or otherwise shall be provided to the department. So if the department is already a party to an adjudicative proceeding, then would they normally receive confidential information sent to the PUC?
Okay. So when the current department staff, which appears now as a party before the PUC, was at the commission, they automatically received confidential information pursuant to PUC rule. But there is no such rule, and there is no statute requiring the department employees to get that confidential information. So we've requested it in statute.
Okay, then,
So,
then,
and it is by statute that the Office of Consumer Advocate, for instance, gets confidential information. And so the department is simply asking for that same type of provision in the statute so that there's no question that they're privy to any of utilities' confidential information so that they can perform the functions of their job.
so follow up, I think that's, I tried to get at this question in the last hearing, and I believe Chairman Bowes had something to say, and you didn't answer me. Does this then present a problem in taking those resources out of the Public Utilities Commission and putting them in an agency where they now have the same responsibility, but they're under different jurisdiction? In other words, that's where the inconsistency in the statutes is coming from, is that those resources who handle those things or had handled those things are being asked to continue to handle those things, but in a different role. Or, in a different agency, under a
Right.
different heading in terms of
Right.
organizational.
Yeah, I don't think that there's any problem so long as the rules are spelled out in the statute, which they are.
Okay, and so that means that those folks will not be discussing the confidential information that they receive with other people in DOE that are not related to their jobs, or
That's-
does,
That is correct.
okay,
Yeah.
thank you.
Is it safe to say then what we're doing here is that we've transferred the work function and the people to the Department of Energy, and so now we're transferring the authority to see confidential information to that same group in a different department,
Exactly.
so they can perform
Yeah.
their job like they did before?
Yes.
Okay. On to page 2.
Okay. So, section 3 on page 2, we discussed that in the context of placing a 5-year period in that.
Is
there
that
another
in there
question?
anywhere, the 5 years? Because I didn't see it.
He has to add it, he said they.
I'll add it and send language to you. Yeah.
Still don't see how
Yeah.
it could work.
Now we can move on to page 2, I guess. Nope, go ahead, Jackie.
I want to go back to what you just said about confidential information that PUC has, I just want to clarify, PUC has the ability and the right to get confidential information when it's discussing a case. Department of Energy has the right to get that information, if I'm interpreting what you said correctly. And the consumer advocate has that right.
That's correct.
That's one heck of a chain of custody.
With the way it was presently set up, the PUC and the consumer advocate had it, but now that we've got the Department of Energy, we have to address that, and what this does is addresses that and allows the Department of Energy to get that confidential information.
And does that assume that the Department of Energy is a party to any of those adjudicative processes?
Yes. So under the current statute, the department is a party to any adjudication before the commission.
Under the current statute?
Yes.
And you did that without any information?
Parties provided us with the confidential information so
Okay.
that we could do our job. It just wasn't specified in statute.
Statute, okay.
But the utilities have been cooperative in that regard. So at the top of page 4, the 3 lines that are crossed out are the fuzzy red line that we'd like to make the bright red line on the previous page.
We're on page 4?
Okay, lines 4, 5, and 6, you'll see are deleted. Top of page 2, I'm sorry.
Yeah.
Line 4, page 2, yeah.
Yeah.
It was a long weekend. So no questions on that?
This isn't new. This was something we had in here before, yeah.
Right.
So, Mr. Chairman?
So,
I actually think this is the language that sort of relates to what I was getting at, which it says the stuff that's crossed out, starting at line 3, provided that other than the administrative functions, department employees shall not communicate with the Public Utilities Commission and its staff in connection with any issue in a matter pending before the commission. I mean, why is that language stricken?
Okay,
Because
that
that's
language-
exactly what I was asking.
that language is actually replaced with other language, which is on page 1. You'll find it
Other
on
language.
lines 19 and 20. So
Okay.
that in adjudicative proceedings, the Public Utilities Commission and the department are subject to a provision of 541A, and that is a provision that prohibits ex parte contacts with someone who's in a sort of a judicial or advisory capacity. So
Okay?
so the language that you see on page 2 is broader than the language in the Administrative Procedures Act
It is.
and has proven to be somewhat problematic because matters aren't defined. It's not limited to adjudicative proceedings. It would include probably rulemakings, you know, if push came to shove. And there's really no reason for that. We ought to be able to coordinate our rulemakings to make sure that we're doing them correctly and dividing our responsibilities appropriately. And there was confusion within the commission and the department and among the relevant parties as to what was administrative and what was not. So people were having difficulty communicating with the clerk at the PUC and getting information out. It made participating in a docket quite problematic. But the language in 541A is relatively well understood. It's the same language that any other agency is subjected to when they're acting in a quasi-judicial capacity. So that would eliminate the confusion and allow the cooperation where it's helpful.
But it also kind of addresses the issue that's been a concern over the years, and that's that when the PUC, as it used to be, they had the staff, and there was sort of like,
Sorry. I feel like I'm leaning over the table.
broke, there we go, just didn't hit hard enough. So, but the staff had direct access to the commission where the utilities didn't. That was considered ex parte. So this sort of addresses that issue to clarify when and where the staff, whatever staff, in this case, the Department of Energy, can have direct access to the commissioners.
Right. So actually, when staff was at the commission, those and commission staff was speaking with the commissioners, that was not considered ex parte under 541A, right? There was a different provision that applied to PUC staff in an adjudication that was eliminated in House Bill 2. But there was a special provision that governed the conversations between staff members and commissioners. It's different from the one cited here.
I'm sorry, go ahead, Jackie. You've had your hand up a while. I was just gonna say, but the confusion is because we've reorganized them so that their staff no longer belongs to them. That's why there's
Right.
confusion.
Right. But
Because
the,
regulatory and executive
Yeah.
branch are not the same.
yeah, I think the confusion was the language that was chosen on page 2.
Yeah.
The appropriate language in that circumstance is the language in RSA 541A, which was what we're asking you to substitute.
Okay.
Yeah.
Thanks.
Go ahead, Jackie.
541A, as I thought I heard you say it, was that it did not allow ex parte communication. Is that correct?
That's correct.
That's correct. So now, as I am listening to this with my very normal brain, does this forbid the PUC and the Department of Energy from talking to each other about confidential information? And if it does, why do they each need it? That's just Does that do that?
Okay, so some of the information that's provided by utilities is confidential by statute. Some of it is confidential because it's really nobody's business who their customers are by name or sometimes by address, right? And some of their internal financials are confidential when you do, after you do the balancing that's required under 91A, right? But in order for everyone to perform their job and regulate the utilities, we have to review that language or, that information, right? And so everybody has to have access to it. That doesn't mean that we're talking to each other about it behind the other party's backs. That's what ex parte means. It means if you're going to have a conversation about it, about that information, then that conversation has to occur in front of all of the parties to the docket. But that's different from who has access to the information that you would have the conversation about. If that makes any sense.
Yeah, Jackie, it would be
So-
like, for example, let's just say there was a rate case, and so the department would be looking at that for what they think the appropriate rate increase, let's say, should be for a utility. Well, in order to make that decision, in order to develop what their position is, they're gonna need access to that confidential information. And obviously, so is the commissioners are gonna need it as well, because they'll make the final call on it. But it doesn't mean that the commissioners and the department are gonna be discussing that information back and forth. They're just both going to have it, so they can both do their jobs.
So, can I follow up?
Sure, sure.
The follow-up would be then, it would be possible, and again, in my normal mind, that the Department of Energy and the Public Utilities Commission could not come up with the same conclusion.
Oh,
And then
absolutely.
what happens there?
Well, if in
Who then decides, quote unquote, whose conclusion is more in the public interest or more correct?
I'm
And
not sure,
So-
when you say conclusion, you mean conclusion of what's confidential or conclusion of the disposition of a rate case?
the
or-
disposition of the rate case.
That'll be the PUC. They have the adjudicative authority to do that, and they'll put out the decision. The Department of Energy would be, you might be able to look at them as if, had a plaintiff and a defendant. I don't like to use those terms, but people can understand
Right.
what I'm talking about. They both make recommendations. Let's just say utility X comes in and says, based on all of our experts and 10 days of testimony and 5,500 pages or whatever, we think we should get a 3.8% rate increase. The Department of Energy looks at all the same thing and says, no, we think it should only be a 3.3% increase. That's going to go to the commission, and the commission will rule. They might rule one way or the other, or they may rule something different, but they have the final say.
They have the final say, but, and again, in my mind, the way it's working, the Department of Energy has the purse strings over the Public Utilities Commission.
Well,
No?
not really. I think their funding is independent from that. They get the money comes in by formula. You can help me out here, David, but I'm pretty sure it just goes all into a bucket at the Department of Energy.
So
And then by fixed formula, so much of that is given to the PUC.
So
It's not
the-
a determination of the Department of Energy,
The-
correct?
The budgets of the Public Utilities Commission, the Office of Consumer Advocate, and the department are determined by the governor and the legislature. You decide who gets how much money, right? All the department does is collect it and put it into the kitty to be distributed, right? But it is the legislature and the governor who decide the actual budgets. And, each agency is responsible for developing its own budget. The department, provides some back office help, to those agencies to help them put that stuff together, but it's really their budget. They take it to the legislature and you folks decide.
Move down the page then, please.
Okay, Section 5, the deletion that you see that says the division shall be an automatic party is replaced by a sentence on page 1 that says the department shall automatically be a party, right? No reason to make just one division a party, because many of our divisions participate. Section 6 is the provision that we requested to extend the life of the PUC's procedural rules until we can get procedural rules in place, which should occur sometime this year. Section 7, this is identical to what was in the bill as introduced, and it essentially replaces the Commissioner of the Public Utilities Commission with the Commissioner of the Department of Energy on the Sustainable Energy Board. On page 3, section 8, this changes some references in the Regi statute from the Commission to the Department of Energy that have to do with developing a report to the legislature. It's the department that really develops that report, and this language just reflects that.
And just so we're clear here, in this section, since we're dealing with, I assume it's 125, when you say department, you mean DES, and then Department of Energy is Department of Energy, correct?
That's correct, yeah.
Okay.
So,
And
late,
this assumes that the Legislative Oversight Committee is not going to be repealed, as we have another bill pending on that?
that's correct. So at the end of last week, as we were going through 125.0 and doing this work, we found a few more references that probably should be changed, which I will be floating to you in an email probably tomorrow. I just need to make sure, I need to discuss it with the Public Utilities Commission and make sure they're on board with the changes that we would suggest making.
Before we leave this page, I had a question on section 10. We talked about for good cause and after notice and hearing, the Department of Energy may accelerate a delay up to 1 year. Okay, this has taken effect a couple of times. Now it's been in effect for some of the wood plants or whatever because they, first of all, it's only class 1 and class 2. Is that the way it is now? Because I thought they did it for the old wood burning plants because we just don't have enough of them running anymore.
I think for the class 3 plants, it's a complete change in the requirement. It can,
Okay.
right? It can.
That's covered someplace else, is what you're saying?
It is, yeah.
Okay. But on this one, making that go to the Department of Energy, the reason I would just want to bring this up, and this is for everybody in the commission's, the committee's input as well, is this could actually affect rates. Because if you go out and you say you have to have, I'm just making up numbers, it has to be 10% of your energy has to be from solar, and you change that to 5%, or you change that to 15%, that means the utility has to go out and buy more or less RECs, which is going to change rates. So should that be done by the Department of Energy, or should and I'm putting this as a question, or the PUC should just take that as an input and say, because this has changed, it's gone down, now the rate should go down accordingly, or because it's gone up, the rate should go up accordingly.
Well, I think this is appropriately at the department, right? The Public Utilities Commission might decide what the rate change actually is. What the department would be deciding is whether there's good cause to change a programmatic feature.
Because you're going to move the percentages one way or
Right,
the other.
yeah.
Okay. I just wanted to make sure people understood that that's sort of a change, because it's Reggie is sort of with the Department of Energy, but in this case, it'll directly affect, I mean, the RPS, but it could directly affect rates if that was changed.
Right.
Peter, go ahead.
Mr. Shulak, can you just give me an idea of what the interpretation of a good cause is? I understand that it says for a good cause and after hearings and so forth, but what are typical good causes where you want to do that? Can you just make up any cause you want?
Well, I would suspect that the types of causes that people would propose would be, say for some reason there were numerous retirements that would affect the supply of RECs, right? And trying to think, I think we had a situation something like that when the steam plants here in town stopped burning, right, stopped burning wood. And so there was going to be a shortage in one of the areas, and that was good cause, I believe, at the time to delay an increase.
I mean, not only was there a shortage, it was a permanent one.
Right.
And there's nothing we could really do about it in the short term. But to be quite honest with you, Peter, that's a great question. But I can remember when this was being debated, I think I was at the commission at the time, and that was the best words we could come up with. That was, so they're not perfect. But if you can help up with better ones, let me know.
Thank you.
So Section 11 was a request of the Public Utilities Commission to change the requirements of what needed to be described in their final orders. And it removes the requirement that the commission state the position of each party on each issue. It doesn't prohibit them from doing that. It just doesn't require it in every order.
And just so people are clear, the entire history of those positions is there, and you can look up a docket and you'll find the filing of Eversource, the filing of Unitil or whatever, and it'll give their complete position. What's been done in the past is then, in the order that the PUC puts out, they will summarize that position of the various parties and put it in their order. It really has no legal bearing, because it's just saying this is our interpretation of their opinion of what they submitted. So what they actually submitted is still there and open to the public, and everybody can read it.
Can I
This
ask
is just
what
an
the
efficiency.
exemption in RSA 541A29 and RSA 541A29A are? Because it's saying, except for those, and I don't think we we probably don't know what those are that are being exempted.
So
It's the bottom
RSA,
of page 3.
Yes, I'm sorry, yeah,
so we're on page 2 again?
Bottom of page
Page
3,
three.
very
final
last
orders
paragraph.
is what I'm referring to.
Okay, so RSA 541A29 has been around for a while, and that is a provision that requires an agency, when it receives an application or a request, it requires within a certain amount of time that the agency identify the person who's handling that request, and that the agency state, what is missing, in terms of information from the request, what is unclear, et cetera. That timeline used to be 60 days. And then it requires action on the application. It used to be 120 days. A few years ago, that was changed to 30 days and 60 days. Otherwise, the agency had to open an adjudicative proceeding, right? Also, just a few years ago, RSA 29, the 29A section was added, and that section states that, unless there's some other timeline specified to the contrary, if the agency fails to meet the timelines in 29, then the application or request is automatically granted as a matter of law, right? And the PUC...
Isn't that a means of enforcement, really?
See if I can
It's
help out.
a means of
It's
trying to get agencies to do things
It's
in a
trying to get
timely
things
manner,
done in a timely
right?
manner, so
Yeah,
we
yeah.
don't prevent long delays. The problem with the PUC is, there's been a number of times when they actually get filings from individuals or small groups of people, and, I'm sure David can give you more about this than I do. They're just totally incomplete. You almost have to walk them through the process and say, you didn't do this, you didn't do that, and then they'll refile and go on. Some of these things, we had a case, I always remember one in Bedford, with an individual house owner who said we were selling them bad, they was sold bad electricity, whatever the hell that means, but, and that went on for, I don't know, 2 or 3 years, I think, before it was finally settled. So this just allows the people to work with especially private individuals, where with the utilities, they have their own lawyers and everything, and I've never seen it as being an issue for those.
Well, I mean, I think some of the language before this addresses that, though. It says, that the agency, when they receive a request, they're required to assess, define what's missing within a certain period of time, right? So if they've defined that an application comes in that's problematic or you know, even if they can't secure the information, right, if they've reached out to the parties that are responsible for that incomplete information, they would have met their requirement, they shouldn't have it waived. I mean, I'm just trying to
So
figure
I
out whether
think-
this
I
makes
think-
things better or worse.
They're not
I
waiving
think-
that requirement, but when you send it back out to them, then
Right.
it could be a month or two before they
Yeah.
respond, and then that deadline for final decision would have passed. And
Okay.
that's the
Yeah.
reason they allow it.
Okay.
because
Yeah, I think-
It's almost always people that are filing as, they don't have the legal skills because they're not a utility with a staff of lawyers,
Yeah.
so.
Okay,
And the agencies were never staffed to handle those types of timelines, right? It was difficult even with the 120 days, the 60 days, it was
Yeah.
nearly impossible. So for instance, when the Consumer Affairs Division was at the PUC, they got 10,000 contacts a year
yeah,
among 5 people,
right,
right? And so just, and you know, the types of requests that would come in often required a lot of hand-holding, right?
yeah,
With individual ratepayers and a lot of escalating with the utilities, and not really possible to do it within those timelines, and most of the requests weren't really suitable for automatic grant, right? They would be problematic if you just automatically granted the requests that came in from the consumers.
Go ahead, Jackie.
Does any of this encompass the site evaluation committee?
No,
None
it
of
does
it?
not, no.
But the site evaluation committee is kind of a hanging out here by the Department of Energy?
So the Site Evaluation Committee is an independent committee, right? Made up of representatives from different agencies at the state. It's only administratively attached to the department. The department doesn't even have a member on the SEC, right?
And there is a major amendment, a
Amendment.
change to that coming from the Senate side
Senate
to us.
side.
Yeah.
Michael, is that past the Senate, do you know? Okay, but it's over there anyways. so.
Yeah, at this point, all we would do is provide some back office support to the committee.
So the rest of these on page 4, unless someone has another question, look like just changing commission to Department of Energy to make,
Page-
is that correct?
So,
I don't see any policy changes other than they just
Okay, right.
replace the commission with Department of Energy.
that's correct, and that's just to make sure that the department is able to collect the assessment and distribute it to the other agencies.
Mr. Harrington?
Oh, sure, go ahead.
Section 2 on page 4. That concerned me because we had given up all control over communications, and we're still assessing, and we're still getting reports, and we're still requiring things of them that we no longer have any jurisdiction over, and I wonder why that's still in there, or that happened years ago when Nada Kane was the chair. And we wondered if that was a good idea, and then we heard that the assessment on the communications here, one of the testimonies was it had doubled. And I wondered why when we don't have
So-
any.
So the assessment statute was revised when the legislature reduced the regulation of telephone companies, right? And they went from a full assessment, 100% assessment on their revenues to a third, right? So their assessments were reduced considerably at that point. And the changes that you see here, which just refer to the collection, don't affect the level or amount of their assessment. The changes on page 4 are really just mechanical. They don't go to the level of the assessment or how much a telecommunications company might owe. This is just the mechanics of the collection.
And if I
Jackie,
could,
down the road, that may be an issue worth pursuing, because it was kind of hanging from when the telephone deregulation. Remember, it wasn't completely because basic service is still covered, but it's a separate issue from this. This is just, like, as David said, if this is just saying commission goes to Department of Energy and it's not making an opinion on those assessments, but it's possibly something for future legislative
But they're
review.
still collecting those
Yes.
revenues, and as we heard here, they're doubling, and that
would-
just,
My point is, it's not really within the scope of what we're trying to accomplish in this bill. I'm not saying it's something we shouldn't look at, but that would be something we might want to look at in the future and not try to get it in here. Because if we start getting to that level, we'll still be here 3 months from now working on this bill, so.
Thank you, Mr. Chairman. I actually have a question at the top of page 4 on the section on final order shall include but not be limited to, and it looks like 2, 3, and, or they were items 2, 3, and 4, now they're 2, 3, and 3 are have been X'd out one way or another, and so all the final order needs to include is the identity of all the parties, and I'm actually concerned with eliminating the concurrence or dissent of each of the commissioners participating in the decision because
Those
it's a-
haven't been eliminated.
They
I mean,
haven't
maybe it's
been.
just the way the
They're
numbering is set
renumbered?
up. Yeah, it should
Okay,
be
so
renumbered.
3 is 2 and
3 is 2
4 is
and
3.
4 is 3. Yeah,
Okay,
but they're
all
there.
right.
There is no, yeah, so this should be, the 2 should be pushed down, if you will, next to line 5.
I gotcha.
But
Okay,
those
so
have
you
not
left
been
the
taken
2
out.
but
Yes.
switch, okay.
Yeah. The only thing that was taken out was the
Thank
position
you.
of each party.
Makes sense. Great.
Sorry.
Okay.
On to page 5 then?
Right. So, section 15. Right. Hold on a second. Section 15 deals with RSA 363B, and these changes are made to clarify that it is the Department of Energy that would review terminations and terminations of service and disconnections of service. All the staff that does that work is now located at the department, not at the commission.
Well, I just
Go
have
ahead.
a question. If they're part of an agency, though, then are they still going to have the same kind of independence to make those decisions? Because it seems like politics can infiltrate there in terms of what those decisions are. Are those people going to be uninhibited in a role within an agency?
No, the disconnections and terminations are governed by rule, right? So they're highly structured.
Yeah.
And all of the detail work is conducted by those people in the consumer division,
Yeah.
right? And there's a whole long process for contacting and setting up mediations with the company, et cetera. And then when it comes to terminations of service, especially for medical disconnections, utilities have to demonstrate that they've provided all the proper notice and gone and knocked on doors, et cetera. And all of that's controlled by rule. So very highly structured.
Yeah, I do understand, but we just had an issue with energy efficiency, which was similarly well-defined in process in terms of how it would be approached and how it would be reviewed and how it would be administered through the PUC, and it
Yeah.
didn't help.
Right.
The rules on the disconnection are pretty long and detailed, some of which go back to, and I'm not sure if you were here then, Dave, it's probably 10, 15 years ago, and I think it was one of the utilities that's no longer in the state, but they had a person die.
Kate Fanoff, and it was June 21st, 2010.
Okay. And that, they died when they disconnected, and after that, there was a big redo of it, and there's all sorts of rules, like you can't disconnect in the wintertime, and you have to go out and
Yeah.
like in-person, I think it's in-person contact with
Yes.
anybody that's on a medical device that registers. And now you probably notice you're getting phone calls from the utilities saying, we could have a power outage, be aware if you're someone on a medical device, so forth and so on. So I think that's pretty well structured.
Yeah.
That was a major waking up point when that
Yes.
person died, so. Good memory, David, by the way.
Well, some things are hard to forget. So section 16, this differs from what was in the bill is introduced. The bill is introduced would have limited the investigations that could be transferred to the PUC for adjudication to just violations by utilities. That limitation has been taken out here. And then new language was inserted here to clarify what would happen to a complaint filed at the department that the department didn't think should be transferred to the PUC. And the new language allows the party itself to take the complaint to the PUC to perhaps get a hearing.
That resolved one of our major issues that we were
Yes.
discussing. I have a big note about that, so that's a big improvement, I think, because it does give that adjudicative process. We had discussed going to the Supreme Court was the next movement. We didn't want to do it that way, so this, I think, is an improvement that everyone had agreed to.
So then beginning on page 6, these are changes to the crossing statute, right? And pursuant to that statute, the state gives utilities and companies that provide utility-type services licenses to cross state land and state water with their equipment. That procedure was fully adjudicative prior to the reorganization, and it was all adjudicated at the Public Utilities Commission. Okay. Now, in reality, there were very, 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 very few hearings on those licensings. The commission would issue, would take the license application, review it, and normally grant the license by an order nisi and give people the opportunity to request a hearing if they wanted one. And in the vast majority of those cases, nobody ever requested a hearing. The commission would, when a crossing appeared to be controversial, have the utility publish it in the newspaper and on their website, et cetera, to give the public notice that somebody had even applied for the crossing. And even then, very few people would come in and contest the license. House Bill 2 divided that process in two and said that whenever all the parties agreed, the department could issue the license, right? And then allowed for a hearing before the PUC if the parties disagreed, right? The problem was there was no way to determine who the parties were unless you opened up an adjudication. So we ended up with two adjudications, one on the department side and one on the commission side. And that first adjudication is really sort of unnecessary, right? So what this statute revision does is it asks to make the proceedings before the department fully administrative, right? So the application would come into the department would review it, would grant or deny the license. At that point, publication would be made so that the world would know that a license was granted, and people would be given an opportunity to request a hearing if they wanted one, which sort of mimics what the Public Utilities Commission was doing all along. That first part was more or less administrative. They would publish the order nisi and give people the opportunity to request a hearing. This sort of follows that model a little bit more closely.
Yeah, just David, if I just interject, what he's saying is 100%. These things used to show up, these order nisi, you'd get them on Friday morning, you'd pick them up, they'd be like 2 or 3 pages. You'd spend 15 minutes reading them and you'd sign the order, and away it would go. There was no hearings, there was no debate, because they were all totally routine. So doing it administratively should be no problem, especially if there is an option to appeal to the PUC. So I think Jackie had her hand up first, then.
It's a clerk question.
Okay, clerk questions take priority.
Clerk question,
What's NICI?
without a hearing.
Without a hearing,
It's without a hearing and with opportunity to request one, essentially.
Please spell NICI.
NISI.
Thank you.
Probably some Latin words, I'm guessing. Yeah. Anyways, go ahead, Jackie.
I was listening or trying to listen carefully to what you were saying, Mr. Shulock, and it sounded to me like first you issue the license, then you get the hearing, and so then if you have a problem, or if there's a major problem with that license or contestation, then you would remove the license or deny it? It just seemed like,
Right. So under the order nisi process, a
Yeah.
person had the opportunity to file comments and an objection and request a hearing. And if after the hearing, the commission believed that the license shouldn't be granted, the license would never go into effect. Right? They would pull back their order. Right?
He's asking under the new process, how would that work? then?
Under the new process, the license would be granted, publication would be made, and at that point, people could request a hearing. When they request the hearing, if the PUC disagrees and thinks that the license should not have been issued, they can order the department to pull the license. That's the way that this is set up.
Clunky.
Yeah.
I have a question. Thank you. Thank you for taking my question. So this is licenses for new poles, and I'm curious how this would be affected with the 5G technology that's pending, because we've had, numerous hearings on the frequency of additional poles that will be needed to support that new technology. So I'm just wondering, is this the kind of thing where a large-scale project of that sort could be approved by the Department of Energy? Second part of the question is, and how long do people have to file if they would like to have it heard at the PUC? Is there a window there that, because oftentimes the public isn't aware that something's been granted, so.
So
I can help out
So-
here. I think the key thing is on this paragraph is that any public utility should construct pipeline, cable, conduit, or line of poles, towers, so forth. The cell companies aren't public utilities. So I don't think this paragraph
Right.
applies to them one way or the other.
So the 5G facilities might be attached to a utility structure, so it
That's
might
what I was
apply
thinking.
then. And then the statute also applies to corporations that want to cross, and they have to do the same application and get the same type of license that the utility would. So
Yeah.
it's not just
Not just
not
public
just
utilities.
public
Yeah.
utilities.
Okay,
But, this would only be for a small portion. This would be, if they needed to cross a state park, right? So it would only be for that portion. It wouldn't be for the entire project, right?
okay, so this is just state land, state waters, as it
Yes.
states. Okay,
Yeah.
thank you. It's hard to
Yeah.
keep asking.
Yeah. One of the other big differences between what's being proposed here and the statute as it currently exists is the current statute has a number of exemptions or licenses by notification. The time period for some of those, for the licenses by notification, has sort of expired. There was an original 2-year time period in the statute for that. So that's been eliminated. There was an exemption from licensing for the crossing of state lands for the purposes of serving the state, right? This would do away with all the exemptions and the notifications and require everybody to obtain a license and for every crossing to be reviewed by the department for at least safety, right? And the idea is that rather than having exemptions or such in the statute, the department's rules would apply the level of scrutiny required for each type of crossing, right? Rather than just saying you're exempt, right? Yeah. Yeah.
Page 7, I see almost no change. One, it says the commission down the bottom of on line 33.
Right. So down to line 27, that's all part of the crossing statute that we just discussed, right? Then Section 19 is as it appeared in the bill as introduced. There are no changes there that we asked for.
Okay. So on to page 8.
Same for Section 20 at the top of page 8. But when you get down to Section 21, this has to do with the attachments statute, the pole attachment statute. There was some back and forth about which agency should retain its authority over safety and vegetation management. And having discussed this with the Public Utilities Commission, we think it should be both agencies retaining that authority, because we each have a little in different areas.
This is section 21?
Section 21, starting on line 8, page 8.
Yeah, I actually don't understand what happened up above that on line 1, because the public good, I thought, was part of the Public Utilities Commission charge, and all those factors that are being considered there seem like they would be with the Utilities Commission, not with the Department of Energy. So I'm questioning that.
Yeah. So the public good is just a standard. It,
Yep.
it says nothing about who would apply it, right? So the bulk of this statute to which this applies is within the Department of Energy's jurisdiction, and I think you can look at the change on page 1 as just an oversight when they were moving things over in House Bill 2.
Good, Fred?
Question I automatically have, when you have two agencies in charge of the same thing, how do you work it out when there's maybe some differences of opinion?
Right. I guess that remains to be seen, right?
I did specifically ask this of the utilities, and the
Yeah.
ones that were here said that they could live with this wording, because I have the same note down as Fred is that, you know, when you have two agencies, what we don't want to do is have, well, you know, the commission said I should do this, and I did it, and then the department says, no, 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 you need to do something else. So
Right.
all I can say is this one, we'll be watching close.
Yeah.
And if this doesn't work, we'll have to make some adjustments in the future. But I don't know, I'm willing to say, give it a shot, because the utilities didn't object. How does the rest of the committee feel? Okay, go ahead, Fred.
I could see something like what happened before, that the Department of Energy has the responsibility, but if somebody doesn't agree, they could go to the PUC for adjudication.
So this provision on line 8 doesn't actually say who has what authority. That's not the purpose of this paragraph. So this is in the pole attachment paragraph, which allows utilities to contract with other companies about what they will attach to their poles and how, right? And what they'll pay for that, right? All that this paragraph says is that the utilities can't contract away the state's ability to regulate by contracting, right? That's the purpose of this paragraph. And so to the extent that the PUC or the department have any authority over vegetation management, which they do, or safety, which they do, the utilities can't bargain that away in a pole attachment agreement. That's all that this is saying.
Thank you, but that doesn't eliminate the potential for conflict.
Oh, no, I think you're absolutely right about that, right?
One other question just on the wording on line 9, where it talks about the Department of Energy and the Public Utilities Commission shall retain their authority. Well, the Department of Energy never had any authority, so they can't retain it. So would it be a little bit more correct to say the Department of Energy and the Public Utilities shall have the authority to regulate? Because they're not, the Department of
Well,
Energy is not retaining anything because it didn't have anything
Yeah.
to retain.
Well, it depends on if you're looking at this at the time that this gets enacted, or if you're looking at it in the context of the utility just bargained for something, but even when they bargain tomorrow, the department is going to retain whatever authority it has over
Well,
safety.
It's not that big of a deal, but
Right,
if you
yeah.
think it's okay the way it is. But I will get back to
And
the rest
I
of.
don't- I don't think I
excuse me,
would
go ahead.
change it to I don't think I would change it to a statute that actually says that both have authority over these two things. That's the problem that I think we're trying to get away from.
I would just like to ask the members of the subcommittee, though, I mean, Fred has a valid point. We have two, possibly conflicting, even though we know they're a big, happy family now. Is that something we want to go forward with and see how it works? Or do we want to say, like what Fred proposed, having one have initial authority and one have appellate authority? And because, this is a question that's going to have to come up, so what do people think? Because when we just go around the room. Hit your microphone, please.
I actually prefer it being left just the way it is.
Okay.
I would prefer that the public utilities retain the authority.
When we say retain, when they would have the appellate authority and the Department of Energy would have the initial review?
No, that the Department of Energy be left out of that because
Completely.
there's a pending sale of poles going on too. So I think that public utilities is where this belongs.
Okay. Jackie? Kate, I mean? Kat?
Oh.
Okay,
Yeah, no, I actually agree that I still think it's with the public utilities. And I think that where the confusion comes in is that many of the resources that are making some of these determinations and have the expertise are from the public utility staff who are now residing in the Department of Energy. And
Right.
so it's just made it more confusing as to how these things get accomplished. But I think the Public Utilities Commission has a separate mission, and I do think that these pieces are regulatory in nature, and that's why I would agree with Jackie.
Okay. Michael? You're here, you might as well get your opinion. Page 8. Yeah.
Yes.
Turn on your microphone.
Yeah, should it be,
Sorry.
this basically the way it's set up now is the department and the commission both have equal authority. Fred had raised the question of, is that gonna cause problems because you have two departments and none of them has the final say? So what Jackie had suggested is just get the Department of Energy out of it. But as Kat had brought up, the problem is a lot of the people that have the expertise are now with the Department of Energy. So I think eliminating them completely would be difficult. Fred had suggested the possibility of the initial approval going through the or the initial review going through the Department of Energy, and then if there was an appeal to that, it would go to the Public Utilities Commission for final.
Well, my question would be, why was it suggested by the Department of Energy that the Public Utilities Commission shall be added to the statute? Because apparently it wasn't there before.
So the current statute says that it's the department that shall retain its authority. And the reason for that is, it is the context of the statute itself. This statute only deals with attachments to poles, right? And in the context of that statute, utilities enter into agreements with people who want to attach, and they can put all kinds of provisions in those agreements that the state doesn't regulate. All this says is that the utilities can't bargain away the state's regulatory authority over things like safety and vegetation management, et cetera. It doesn't say anything about who actually has that authority. So for instance, we have safety rules, right? And we'll probably adopt some additional safety rules, as we get going, right? Vegetation management, that's all handled in dockets. There is no rule that governs vegetation management. That's really done sort of in the context of rate making, believe it or not, where you're deciding what goes into which budget and how readily accessible that money is to the utility through their rates, right? When they get paid back for the work that they're doing, that sort of thing. right? And so that's more within the PUC's ken, and the people at the department are taking a position under their regulatory authority, which is basically to take a position and argue, right, on that subject, and then it gets resolved by the PUC. So there is no clean line that we can draw in this area, at least not at this point. I think that's a project that's well beyond what we can do here in this session.
But on things like safety, for example, the people that would be responsible for that are in the Department of Energy and not in the PUC. Those people have been moved over, correct?
Yes, those people have been moved over, but that doesn't mean that they wouldn't appear before the PUC
Right.
to make arguments on an issue that the PUC would have the decisional authority for. Right.
So was this original change to statute made by HB2?
Right, so the original statute said the Public Utilities Commission shall retain its authority, right? House Bill 2 changed that to the department shall retain its authority, and what the PUC and the department are suggesting to you is that it should be both, right? So whatever authority each one has, they retain it in that process. The utility cannot be permitted to bargain that away in its attachment agreements.
I'm satisfied with this language as written.
Fred?
Listening, which I sometimes do, I think that leave it alone. Let's see if let it play out and see if there's a problem in the future. Because I heard about it's difficult to unwind. The department has this and PUC has that. Some of it's in a rate case. Some of it's administrative. So let's leave it alone and see what the problem crops up in the future. I may have been thinking of a problem that won't exist.
Well, I think these are things that you do need to think about, right, as do we. And we're going to be thinking about this as we go through our rulemaking project this year, right? And we'll be working with the Department of Justice on that to make sure that we're appropriately assuming the authority that we should assume and not assuming authority we shouldn't, each agency, right? And I think after that, if there are problems, they'll become more clear, right? Such as, well, if the department sets a rule, can the commission require some type of behavior that's above and beyond the rule that the department has set in a certain area? Those issues will arise at some point, but I don't think it's something that can be resolved today. Yeah.
I can accept the language as it is, although I do agree as you're going through the actual mechanics of the next year or so, the proposal that Fred had outlined makes sense, that you consider driving all the initial work into the Department of Energy where the staff is, and if there's a conflict, then the PUC is the adjudicatory body for resolution. That makes sense if this becomes unworkable.
Here?
Yeah, my instincts are more towards what Jackie was saying about the Public Utilities Commission having the major role here, because of the fact that this is a regulatory authority. However, I think because of the way this was restructured, as we know, we have people who used to do one function are now in a department that really has a different function. And then the question is who takes care of the regulatory versus planning and other things. And I think this is going to be a reoccurring problem. This is not the only place where this is going to happen. It's going to happen over and over again because this is a major overhaul and major shifting around of people with different expertise. And you don't want to lose that expertise, but at the same time now they're under a different authority. So it's really a tricky thing to do, and I think at this point maybe the best thing would be to leave it as is right now, but to keep a really sharp eye on it. And as I mentioned a couple times and requested a couple times, we really need to get a better overview of this whole reorg from your department, and a lot of the answers about, you provide us with some comments now that may be new to us, but not new to you, so we need to be updated in what's exactly happened, where people are, what authorities got shifted, and I don't think we've gotten that kind of information. As I mentioned, the last time I think we got an update was May of last year. So that's way too long.
Right.
Thank you.
So Representative McGee made a comment at our last meeting. She just wanted to know whether the structure had been implemented the way that you were shown, and it was, right? So that's the structure that's been implemented. That's where people went in terms of the department or the PUC and how the different divisions are structured.
I just to follow up to, I think Peter had an excellent point there. This is not going to be the only issue where we come in and say DOE, commission, both separate, one above the other, whatever. So rather than try to come up with a unique solution for each one, I think what he suggests is we just let you guys know we're going to be looking at this closely. Obviously, if there comes to be problems, the utilities and the people that do pole attachments, which are, there's like a zillion different companies out there attaching things to poles these days. They are not shy. They will let us know if there's a problem. So I think maybe trying to see what works rather than try to find a unique solution to each one may be the best approach.
I think maybe some of the confusion here is results from the fact that the commission, up until HB2 occurred or was passed, the commission was doing a lot of non-regulatory kinds of things. And what HB2 does is it gives back to the commission just those things over which it should regulate, which is mostly rate setting, and it creates the new Department of Energy to administer the rest of the legislative mandates with regard to energy. So people have to kind of separate in their minds that the Department of Energy is like the Department of Transportation, can regulate things relevant to its area of expertise, but the Public Utilities Commission regulates a very narrower set of things than the Department of Energy does, and is more adjudicative in the process because of the nature of rate setting. So I think if we keep that distinction in our mind, it'll be easier for us to understand why some of these changes are being requested.
Thank you, Mr. Chairman. Mike, I have a question. We've been talking back and forth about who does what, and that we've transferred resources over that do investigatory pieces that used to be PUC that are now DOE. And I think my question is, if the Public Utilities Commission were the sole responsible party under this language, they would still have access to those people for the investigatory piece of determining any of these issues, right? They become sort of an extended administrative staff to the PUC when they're doing their work, right?
Well, so let me see if I can come up with an example as to why it should be both.
I mean, we have to understand that, because now that they
Let
don't
me
have
see
any
if I can
staff.
come up with an example as why it should be both who have the regular, retain their authority over these things.
Okay.
Okay, so if the issue were to come to the commission, right? And the commission wanted the department's aid in understanding the issue,
Yeah.
right? The commission would have to have authority over something like safety so that they could make the decision. The department would have to have authority over safety so that it could fully go in and investigate and require answers, right? And require some initial changes, right? Maybe before it goes to the litigation, right?
Yeah.
So if you were to just say that the Public Utilities Commission has control over it, then what would the department do? How would they even help,
Yeah,
right? So,
yeah,
anyhow,
yeah,
that's the best I can come up with on the
It comes back to
fly.
what I've been mentioning all along, though.
Yeah.
This is the problem with building the plane while you're flying it, right? Is that I understand there could be endless back and forth trying to figure out how the department would work without putting it in place and then
Mm-hmm.
tweaking. I understand that there's, there's different ways to approach doing that and different values to doing it each way. But it seems like the issue still keeps coming back to the fact that the Public Utilities Commission no longer has its own investigatory resources. And so it's going to continue to have this back and forth with who does what, why, when, who has authority, when, where. And that is going to be confusing not only for the regulatory process, but also for the people who interact with those two bodies. It's not just going to be internal. And
Right. I'll-
I think it's unnecessary. I think what we've done here is an unnecessary confusion of the two.
So let me see if I can give an example of how it works, right? So recently, 2 telephone companies applied for a boundary exchange, right? Because we do still regulate some things having to do with telephone, right? So they applied for the boundary exchange, and the commission issued a procedural order asking the department to investigate and prepare a recommendation within a certain amount of time, right? Now, the red line required the commission to do that on the record, right? So the companies know that the department has been requested to prepare the investigation, but the department has regulatory authority, so they can actually conduct that investigation. They'll file the recommendation, and then the PUC will take action based upon what the utilities have said and what the department has recommended. So everything's working, right, in terms of where the resources are and who's doing the work, and everything's on the record so everybody sees it. And that's the fundamental design, I think, of House Bill 2, and it functions. It's working.
Peter, you had a question?
Thank you. Yes, I kind of want to respond to what Chairman Vogt just mentioned. I understand his thinking that, we've changed dramatically the structure of things, and now the Department of Energy has a lot more authority and authority they didn't have before. But this example here with the pole attachment is contradicts that very argument, because then there shouldn't be the PUC in here. The DOE should be the only one in here. But now you put both of it together with both of them have to agree, and this kind of confusion is contradicting maybe the intent of what should have happened. And I don't think that that's going to get resolved easily just because of just this one item here.
So in the context of this statute, both do not have to agree. Pole attachment issues do not go to the PUC at all unless the pole owner and the person who wishes to attach can't come to an agreement, right? If they can't come to an agreement as to the terms and conditions and pricing of the pole attachment statute, that all goes to the PUC for litigation, right? So that's all that's going there. Now, there might be a safety issue involved, where an attacher wants to attach in the electric space, right? And the commission's going to say, absolutely not, you can't do that, right? Just as the department would say, absolutely not, you can't do that. Right?
But the sentence says, like Michael was just saying before, retain their authority. So on the one hand, you say this is a PUC issue. They're the people having the authority to do this. But then it talks about the Department of Energy retaining some authority over it. Well, they didn't have authority before, right? So this is something new.
But I think you're looking at it in terms of when the statute is enacted, as opposed to where this falls in the process, right? So this is where it falls in the process of retaining.
Excuse me, though, because I was wrong on that. The HB2 presently gives the authority to the Department of Energy, so they are retaining it. So it is the correct term. I
So
just,
it's
I
the
just read it
H-
wrong.
HB2
HB2
version that
already gave it to
retains
them, yeah,
that.
and they retained
But-
that.
So
It's-
this,
but
this act
beyond-
suggests expanding that
Yeah,
then.
but
right?
Puts in
beyond,
the
beyond
PUC.
that, I don't, this really has to do with where the paragraph falls in the process of attachments, not where it falls in the process of adopting statutes. Not, it's
So
not on
just a
that
small
timeline.
slice of that process. you're saying.
Exactly, right? So all this is saying is that in the process of entering into a pole attachment agreement, the utility and the attacher cannot bargain away the state's authority to regulate, right? So when you're in that process, you
Regardless
can't
of
do-
who has that authority.
that's correct.
Okay.
Yeah. So yeah, this doesn't deal with who has the authority or what authorities they hold. It's just whatever we hold, you can't bargain it away. Whatever you agree to, doesn't matter. We're going to come in, we're going to regulate safety.
Okay,
We're
thank you.
gonna have to move on because we can battle this thing for forever. So going down the rest of the page, it looks to me, under section 23, that these are just changes, which I think were in the original, from Commission to Department of Energy. There's a number of those.
I'd like to look at number 4 on line 15. The
I'm sorry,
piece,
what page are you on? Kate?
I'm on 8 before we're
8.
glossing by the rest
Okay.
of what's on that page. Under open access to transmission and distribution facilities, we're leaving the first sentence, and I would like to ask whether we could leave the last sentence as well, which I think has relevance in the statute and was there for a reason. It's the commission and the department should monitor companies providing transmission or distribution services and take necessary measures to ensure that no supplier has an unfair advantage in offering and pricing such services. I think that language was there specifically to make sure that that is taken into consideration under open access to transmission and distribution facilities. And it was part of the original restructuring policy principles. So I think that that language should be retained.
Go ahead.
I think that's up to you folks. I mean, we'll do that work if you ask us to.
I know. it's
So
not-
the sentence says, the sentence that Representative McGee referred to says the commission and the department. Was that changed in HB2? Was that language changed in HB2? What department is the sentence referring to?
Yeah, it would be DOE, because in the HB2, it said that those would be the references, right? Department would be DOE, so that's where it came from, I'm sure.
I think it's a valid request. I don't see why we wouldn't want to leave it in unless someone sees something I'm missing. So
I
would you-
think Representative McGee's right on the money.
You want to put that one back in then? So that's on line 20 of page 4,
Thank you.
or page 8, I'm sorry.
Okay, so section 23 is one that we've talked about a couple of times. This is a ratepayer protection provision, and has to do with providing notice of when you're going to use a variable rate, and the appropriate party to report that to would be the department, because we're the people who list it on the website. Yes. Okay. Yes. Yeah. Yeah. So section 24 at the bottom of the page has to do with the so-called Sbc report that is provided to the legislature every year. And House Bill 2 had the commission and the department submitting that report, but the commission really doesn't have anything of its own to say about that. So our recommendation was that you just have the department prepare and submit that report. Section 25 on page 9.
This is another one of those sections, sort of similar to the one we were discussing before, in that you're going to have two the two groups, the department and the commission, having to really work together here. I mean, for example, I know one of the commissioners was just down at the NARUC meeting in Washington, where they passed a resolution between FERC and NARUC to work on some transmission siting rules. And obviously, when we get back to New Hampshire, the part of this, our state that's gonna be working on the transmission issues, dealing with NEPOOL and ISO New England, is gonna be the Department of Energy and not the PUC. So, the sentence you added in here, employees of the commission and department are not otherwise prohibited from participating, et cetera, it was definitely needed. But again, and just a heads up on this one, this is an area where we could have potential conflict, and we're gonna have to make sure that the two groups work together seamlessly, because these things aren't that clear, especially once you start going into regional issues.
Right.
So,
Section 26, beginning on line 22, this was in the original House Bill 1258 as introduced. So no changes there.
Excuse me, could you say that again, please? How, it was where?
So beginning on page line 22 on page 9, section 26, we did not make any changes to that. This is how it appeared in House Bill 1258 as introduced. So this is all language you've seen before.
Oh, okay.
Yeah.
So did this result from last year's Senate Bill 91?
As I recall, yes.
Yes, okay, thank you.
So section 27 was also in the bill as introduced. It's just a reference change in the budget from adjudicative commissioners back to Public Utilities Commission. I think because adjudicative commissioners is difficult to say. And section 28, that took out the repeal of the RSA 374 F34. That's on page 8 now. And so the open access transmission provision in House Bill 1258, that was completely repealed, right? So you no longer see that in the repeal section.
on section 28, then, these are repealed, this was in HB 2 or 1258 as originally submitted, or?
Okay, so RSA 12P12 was a mistake in House Bill 2 because that provision actually appears in the PUC's own statutes. So that's just a housekeeping measure.
Okay.
2, 3, and 4, the 371 sites, those are changes to the crossing statute. These are the exemptions that are being removed so that everybody comes in to the
Okay,
tent to get a
okay,
license, right? And then RSA 374 F3 5B, that repeal was in 1258 as introduced, and that's because that provision's been superseded
Okay.
by time, right?
Thank you.
So
Go ahead.
there was one mistake that I made. Gotta find it here in the provisions. I think it was section 8.
We're losing your volume, David, if you could just get a little closer, please.
What section did that end up in? Okay. Okay, no mistakes made. We're okay, yeah.
Go ahead, Fred.
If we're through, I'd like to summarize what changes we still need to make, so we get another amendment, it's complete. And the ones that I remember is putting back in the 5-year, you have 5 years to change rules.
Yeah, but I think that was intended to go in section 6, where we're getting the exemption from 541A17(2).
Which page are you on?
That would be page 2, line 16. I think that's where you had actually talked about the 5-year.
Okay, as long as we get it in there then.
Okay.
Okay, so page 2,
Okay.
line 16.
Just so you note down to provide language. Second was the Mcgee, the amendment with respect to the database, which should be incorporated in here.
That we haven't addressed it. Let's just give can we go over what we've done so far today, and then we'll get to that afterwards. So, go ahead, Fred, you can continue.
Well, I'm just summarizing what I thought were
yeah.
changes. Third that I remember is adding back a sentence that was deleted. On page 8, lines
20.
16 to 22, the last sentence, starting the commissioner of the department, should be added back in. Those are the changes I remember.
That's the ones I had written down as well, so if anyone has anything else.
Okay.
Now, Kat,
Then, in addition to that, I said that I would be sending around some additional changes to RSA 125O, just in terms of changing department to commission or
Yep, you had mentioned
some very simple changes to that.
and we have the so-called Mcgee Amendment. So where is? Okay, I'm sorry, what?
For the dyslexic,
And
not 1258.
where would we put that? Do you have any particular spot? I mean, this is just, this bill, there's a lot more to HB2
Yeah,
than that.
the language in 1285, which I didn't bring my full book with me, so I don't have it in front of me,
Michael,
but
can you help out here at all? or-
I think you already did send that along to OLS, though, right? The bill?
Well, Matthew Young, who was the OLS attorney, informed me that Mr. Shulock had addressed this in his
Oh, okay.
document, but I didn't see anything in the document we supplied to OLS that
About
addressed this change.
House Bill 1285?
1285,
Yeah, the statewide
yeah.
energy data platform with the security and privacy language. We had just agreed that we can ITL that bill if we can include that language here in updating the language around DOE and
Okay.
PUC.
So in the
It's
language
just a
that I...
one-word change
Okay, so in the language that I send you, you want me to include the language from
of
1285?
1285.
That'd be
Yes, please.
helpful, yeah.
Yes. That way we can be assured it gets in. Mr. Young apparently got confused when I asked him to put it in because he didn't know where it came from, I guess.
You should start attending our meetings.
Just a question, is HB 1285 has not been amended, it's HB 1285 he can get as introduced and incorporate it? Thank you.
Okay, so we've got 3 changes. When do you think, as far as time-wise goes, and I'll defer to the chairman on this, when do we need this by? Let me put it that way.
We're execing this bill on Tuesday, March 1st, which is a week from today. So we would need the completed amendment by Friday of this week. So it'll have to go, your document, Mr. Shulock, will have to go to Representative Harrington. He'll have to contact OLS to get the amendment drafted
Okay.
because I'm going out of town.
Okay.
So
So is Wednesday okay?
The only drawback, I say, Michael said Friday, but we're talking about a snowstorm Friday, so maybe OLS isn't here.
I'll
So
do
if
my
we could
best to
get it-
have it to you tomorrow.
Yeah, or even, what's today, Tuesday, late Wednesday, whatever time, or early Thursday, so I could get it to them, just in case there is a storm and things get close. And I'm hoping then, based on that, we can take the amendment as is to the executive committee, or to exec it on, what is it, Monday? We have that?
Tuesday, March 1st.
Tuesday, March 1st, okay. So I'll make sure when I get the thing from, when I get it back, I'll distribute it to the entire committee, I guess. That'd be best, okay. So have anything else on here? I just want to thank everybody for showing up. Spent a lot of time on this. Want to thank the people from the Department of Energy. You're been more than helpful. We couldn't have done it without you, and hopefully we're making your life a little easier. And we'll look forward to realizing you'll probably be back with some additional changes as you work out a few more kinks in this, but we'll take it one step at a time and hopefully make the process better. So with that, I'll adjourn the subcommittee hearing.